Hi everyone, this is your last video lecture for Chapter 2 for criminal law. So in the last two lectures, we did an overview of the Constitution and how it affects criminal law. And then in the second one, we went through the step-by-step process of doing substantive due process analysis. So hopefully you've worked through that, you've looked at some of the problems, and you've worked on the homework for doing those problems. So if you have any questions, just reach out and I'll be happy to work with you on those. So the last thing I want to talk about are those fundamental rights, because we said our first question is always, is it a fundamental right? So that's what we have to learn. What are those fundamental rights? So today I'm going to look at specifically some of the rights that are in the Bill of Rights, and then specifically we're going to talk about the First Amendment quite a bit, because that seems to be the amendment that's greatly affected the most when we talk about criminal law. So I'm going to share my screen with you, and hopefully you can see that, and we'll work through the PowerPoint. So as we said, we worked through that substantive due process analysis. So now we need to know, what are our rights? What are our fundamental rights, and when could they be infringed? So we're going to start first by looking at the First Amendment and what the different rules are for the First Amendment. So what do you think about this? Mary opposes the U.S. military operations in the Middle East. She went to a public park, stood on a grassy knoll, and addressed a group of 12 to 15 people. She said, "Let's demand accountability from our government. If the U.S. won't pull out of the Middle East, let's assemble, detonate bombs, and plant them outside military bases until we withdraw." No one responded to the speech, but one listener waved approval. Mary is arrested under a state statute that prohibits advocating insurrection against the federal government. What do you think? So we have to think about it in terms of fundamental rights. So we know that the First Amendment says you have the right to free speech. It's a fundamental right. So the question is, does this violate the First Amendment when she's arrested for speaking? So we're going to look at First Amendment specifically, because there's some specific rules that go along with it. Now, just as a little refresher, hopefully you remember all of the First Amendment, but here it is. You can always Google it if you need to. When you're talking about the First Amendment actually provides for 5 different rights. So freedom of speech, freedom of religion, freedom of the press, freedom to assemble, and freedom to petition the government. So it's lots of different rights. We're really today just going to focus on free speech, freedom of expression that goes with that, and then we'll talk a little bit about freedom of religion. So the first thing we want to talk about is free speech. So we know the First Amendment says we have freedom of speech. So obviously that means words. The words you say are protected. The speech between two people is protected. But the question is it only words that are expressed, or can symbols, if you give somebody the finger, if you do certain things, is that considered speech, or does it have to actually be words that come out of your mouth? And the courts have said it also includes symbolic speech. So it's not limited just to words that you say. It also can include what we would call symbolic speech, thumbs up, something like that. That's all a form of speech. So it's really freedom of expression. We have the right to express ourselves, either with express words or through symbols or ways of acting. Now, the next question is free speech absolute? Are you allowed to say anything you want, anytime you want, anywhere that you want? And we know that that is no. We have the law has the ability to limit some of these rights in certain circumstances, but only if your limiting rights passes that strict scrutiny test. So what we talked about in the last class, we have to go back and use that. So the courts can limit, or the Congress can limit some of these rights, but only if they pass that compelling reason, least restrictive test, the strict scrutiny test. So that has to come back, and we have to use that. And basically what we're doing in those situations is we're trying to protect society from certain things, screaming fire in a theater, but also protecting our rights, our First Amendment rights to freedom of speech. So we're trying to reach that balance. So we use a strict scrutiny test to see if we've reached that actual balance. So using that standard, can you be arrested for displaying colored photos of aborted fetuses at a busy intersection to protest abortion? We have to think about that. Our speech is not absolute. Would this be okay? So we'd have to think about our substantive due process test. What right are you claiming? You're claiming the right to protest, free speech, freedom of expression. Is it a fundamental right? Absolutely. So now we're using strict scrutiny test. Does the government have a really, really good reason for not wanting you to display these things at a busy intersection? So think about some of the reasons why the state would give. Maybe it causes car accidents. Maybe there's little kids and it would be disturbing to them. So if that's a really, really good reason, then you pass that part of the test, and then you still have to pass the least restrictive. So are they saying you can never protest abortion or never use displayed photos? No, they're just saying at busy intersections. So it probably would be also the least restrictive. And the Supreme Court said, yes, you can restrict it. It's okay, because there is a really, really good reason, public safety or distracting, that is compelling, and it's only limiting it in those certain places. So it is constitutional, even though it does limit our free speech. Can you be arrested for burning the American flag? So you're at a protest, you're mad at the government, and you want to burn the flag at the protest. So what amendment are we talking about? First Amendment, freedom of speech, freedom of expression, burning a flag to show that we're unhappy with our government, okay? Does the government have a compelling reason, a really, really good reason for not allowing you to burn a flag? Some of you may say patriotism, unity of our country, it's a symbol of our country. You have to decide, is that a compelling enough reason to not allow people to assert their freedom of speech? And in this case, the Supreme Court said, no, that's not a compelling reason. Just because we don't like it, just because we think it's rude and unpatriotic, is not a really, really good reason. And so therefore, you cannot make laws making burning the American flag a crime, okay? There's no compelling reason for it. So hopefully you get that and you're applying that test that we learned before. So one of the two things you have to remember when you're talking about the First Amendment, you can never regulate content. So we're never going to tell people that there's certain subjects they're not allowed to talk about. We're not going to regulate content. But one thing we can regulate is time, place, and manner. So we can say, we can't tell people what they can and cannot say, but we can tell them, if you want to say it, you can only say it at this time, at this place, and in this manner. So we're allowed to restrict the time, place, and manner, as long as we do it in a way that doesn't completely take away the right. But we try not to regulate content. So what actually are the words and the meanings that we're trying to convey? So when you're trying to think about if the law is valid or not, think about, is it trying to keep people from saying specific things? Or is it just regulating the time, place, and manner where they can say those things? So using that, let's think about some of these. Can you outlaw the use of sound amplification at a protest outside a courthouse? So there's a trial going on and they're protesting the trial and they're using big bullhorns and huge speakers and just blasting sound. Can they limit that? Are they limiting what they say, or are they limiting the time, place, and manner of how they're saying it? That would be a manner limitation. They're not telling them they can't say certain things. They're just saying you can't use these huge sound amplifications to do it. Can you outlaw a rally outside a person's home at all hours of the night? Again, are we regulating what they're saying, or are we just saying where, when, and how they can say it? If it's where, when, and how, then that's a manner restriction, a time and place restriction, and it is okay to limit that. We're allowed to limit it in that way. Can you outlaw the F word completely? Is that content or is that time, place, and manner? That is content. We're actually telling them what they can't say, not time, place, and manner. So that would be unconstitutional. It cannot be regulated because it's regulating content. Okay. Now, remember we talked about the vagueness doctrine and the overbroad doctrine. So when you are looking at laws that try to limit what can be said, First Amendment, freedom of expression types of things, first you have to read the law and say, does it clearly define what you can and cannot do in sufficiently definite ways of being able to enforce it, the vagueness doctrine? Or is it overbroad? Does it take away too many of our freedom of expression, freedom of speech rules? So anything that regulates content, unless it's very narrow, is going to probably be unconstitutionally overbroad. We don't want to have laws that outlaw legal speech, so that's overbroad, and we don't want people guessing what they can say and what they can't say. That would be vague. So those terms are going to come back and haunt you. You got to make sure you understand how they apply. Now, when we're talking about protected speech, there are certain things the Supreme Court have said are so completely lacking any value, we're not even going to call them speech. So we're not even going to consider them expression or speech at all. So these are sort of exceptions to the First Amendment right to free speech. The first one is advocating unlawful conduct. So you are not allowed to advocate for people to commit crimes, but it is narrowly tailored in the sense that this is only going to be not protected if it leads to what we call imminent lawless action. So as long as you say something and it doesn't lead to immediate criminal activity, then you're probably okay. But if you're stoking the crowd, if you're getting them to break the law and they immediately do something that you advocate for, then that can be a crime, and you can be arrested for that, even though it was free speech for you to say those things. So if I say, let's, kill Johnny Smith, and everybody just looks at me and just ignores me, and that's not going to be enough. But if I say, let's kill Johnny Smith, and everybody jumps up and starts to run to attack Johnny Smith, that's imminent lawless actions leading to immediate criminal behavior, and therefore it can be a crime. So that's where that comes into action. The next two are fighting words. So there are certain words that we consider so horrible that if you say them, it would immediately cause somebody to go into a fit of rage and just start fighting. Those are also not protected. It's pretty hard to find fighting words anymore. It used to be racial slurs. When we were young, it was always your mama jokes. If somebody joked about your mama, you were going to attack them. But there's not very many things now that fall under this. So the only thing maybe is still the hate speech, the severe racial types of things. But other than that, there's not a lot that falls under fighting words, because we don't want a lot of things to be regulated. We want as much free speech as we possibly can. The last one is what we call obscenity. Obscenity is what we will call sick sex, and we'll talk about it at the end of the semester. But it's a depiction, it's a awful, terrible, patently offensive portrayal of sex. So that if it's declared to be obscene, then it's not protected by the First Amendment free speech. So the only two things that really are not protected with obscenity anymore would be violent rape scenes and child pornography. Everything else isn't really going to fit anymore. But those two things do not receive First Amendment protections. So when you see these things, they're considered so utterly lacking any value that they're not even considered speech. So child porn cannot be considered speech. Fighting words cannot even be considered speech. Language that advocates people to commit crimes, not speech. So they're not protected by the First Amendment. So what about engaging in a sit-in to protest racial segregation? So you're not saying anything, you're just sitting down. Is that a form of speech? Yes, it's a form of expression. Can we regulate that? Can we stop that? And that would be no. We would be able to do time, place, and manner restrictions, but that is protected speech still. Speaking at a rally and advocating overthrowing the government. Is this protected speech? I hope you say it depends. Does it lead to imminent lawless action, or does everybody just look at them? If they don't do anything, then it's protected speech. If it leads to somebody starting to commit crimes, not protected speech. Wearing swastikas and parading through the streets in a predominantly Jewish neighborhood. Is that protected speech? The courts have said yes. The courts have said that does not rise to the level of hate speech, and therefore it is protected and they're allowed to express themselves in that way. Hanging a noose from a tree, often a symbol of you're going to hang somebody, often used against minority groups. And that is also protected speech. It's not considered hate words. It's not considered advocating unlawful conduct. So it is protected speech. So as you can see, sometimes these are horrible, awful, terrible forms of speech. And I would hope nobody ever would want to use these forms of speech. But they are still protected as long as they don't fit into one of the three exceptions. And unfortunately, if we want freedom of speech, we still have to protect people saying awful, terrible, horrible things. As long as they don't advocate unlawful conduct, they're not hate or they're not obscene. So they are protected. So what about this? A seventh grader wears a t-shirt to school stating that President Obama was a terrible president. The principal tells him to either change his shirt or cover it up with duct tape. Excuse me. Or a prisoner is not allowed to have certain reading materials in his cell because they said that they're disruptive. So the question is, do either of these violate the First Amendment? Well, they're both freedom of expression, right? So you would think that they would be a violation of the First Amendment. And then you would have to say, though, is there a compelling reason for limiting either one of these things? And the answer is yes, there are compelling reasons. And what the school said is schools and prisons need special protection against free speech for schools in order to maintain a learning environment, acceptable learning environment, and prisons to maintain safety. So there are allowed to have speech limitations in these settings because there's a really compelling reason to limit what people are saying in these settings. So let's go back to Mary. So Mary was protesting against the government. She says, let's overthrow the government. And one person just kind of waves at her. Is Mary's speech protected? Now that you know the test, what do you think? Yes, Mary's speech would be protected. Even though it is advocating unlawful conduct, it has not risen to imminent lawless action because nobody started to commit any crimes. So therefore, to arrest her would be a violation of her First Amendment rights because it's not rising to what would not be protected. Okay, that's free speech. So I just want to talk real quick about some of the other amendments so you have an understanding of what some of the other amendments are. So another provision in the First Amendment is freedom of religion. Freedom of religion includes two separate things, Establishment Clause and free exercise. So Establishment Clause is dealing with more developing or having one main religion for the country that everybody has to practice. And then the second one, free exercise, is allowing people to actually exercise or not exercise their right to religion. So if you want to go to church, you can pick your church and you can choose to go. You can also choose not to believe in religion and not go to church. That is also free exercise. So whenever you have a law that's dealing with freedom of religion, is it violating or is it establishing one church and preferencing one church over another? Or is it limiting people's ability to practice religion in any ways? If it does, it's going to violate the Constitution and it would have to pass the substantive due process analysis. There would have to be a compelling reason for it and it would have to be least restrictive. So a New York school board creates a neutral prayer and makes every class say a neutral prayer every day. So think about it. Requiring students to say a prayer. Is it violating establishing a religion or free exercise? It would be free exercise, because what if you don't want to believe in any religion? And it would be forcing you even neutrally to say a prayer. Laws that outlaw Mormon beliefs in polygamy as a religious practice. So some religions believe you can marry more than one person at a time. Is it a violation of your right to freedom of religion if we pass a law that says you can't? Well, you would have to ask yourself, is it a fundamental right? Yes, it's your religion, but is there a compelling reason why the government would not want people marrying more than one person? And the courts have said, yes, there are compelling reasons. One person supporting multiple families, the government being responsible to help care for those families, and just moral grounds, morality crimes. So that there was a compelling reason for it. The school district compels all students to say the pledge and salute the flag. And some religions don't believe in it, Jehovah's Witness. So if you force people to do that, does that violate one of the provisions of the freedom of religion? And it is yes, because if they don't want to say the pledge and under God, they shouldn't be forced to do that. It violates free exercise. And is there a really compelling reason to force them to do it? No, just patriotism is not a good enough reason. So therefore, if you forced them, it would violate their First Amendment rights. Okay. Native Americans arrested for smoking peyote. He's also arrested for snake handling. He claims they're his religious ceremony. So it's violating First Amendment right to religion. So is there a compelling reason why the government wouldn't want people smoking what they consider illegal drugs or snake handling? And the government say, yes, we have great reasons for that. We don't want people on drugs. We don't want them handling snakes for safety reasons. And the court agreed. So there are compelling reasons for that. So even though it is infringement on his freedom of religion, it's going to be okay. And the last one, a law requiring Kentucky courthouses put the 10 Commandments up in all the hallways. Is that a violation of my freedom of religion if I don't believe in the 10 Commandments? And it would be yes, establishing one religion over others. It's an establishment clause because you're choosing religions, Christian religions that believe in the 10 Commandments over other religions. And therefore, it does violate freedom of religion. So let's just quickly talk about some of the other amendments. The Second Amendment often comes up whenever you're trying to regulate guns or weapons and make certain things a crime. You have claims that it violates the Second Amendment. We know that in the Supreme Court has basically said in a couple cases that you do have a constitutional right to bear arms. So then the question is always going to be, can they limit it in any way? If they're going to limit that right, it has to have a compelling reason. It has to be limited as little as possible. So a lot of the cases for the Second Amendment are dealing with how are those limitations? Do they take away too many rights? Are the restrictions too restrictive that they're causing people not to really have the right to bear arms? The Eighth Amendment. The Eighth Amendment deals with punishment. So do we have cruel and unusual punishments? When we look at criminal law and we look at the punishments for those crimes, we need to say, does the punishment violate the Eighth Amendment? Basically, what the courts have said is it will violate a fundamental right against cruel and unusual punishment if it's cruel or unusual punishment. So is it barbaric? Is it cruel? Is it awful? So anything that disfigures the body or causes lingering pain, like torture, is going to be cruel and unusual. And so that's why you don't see those forms of punishments anymore, because the court said they do violate the Eighth Amendment. Okay. The other thing so barbaric is cruel and unusual. So, cutting out intestines, tarring and feathering, all of those old torturous punishments are no longer acceptable. The other thing that violates the Eighth Amendment is what we call disproportionate punishment. If the crime is disproportionate to the crime. So if I give the death penalty for chewing gum, that's going to be a disproportionate crime and a punishment for that crime, and it would be unconstitutional. So we need the crime, the punishment to fit the crime. So we rank all the crimes. We have to figure out what's the appropriate punishment depending on where that crime ranks compared to other crimes. If the punishment is too harsh compared to other crimes, it will be unconstitutional. Okay, so tarring and feathering, these are the examples I gave. Electric chair, there's been arguments that's cruel and unusual because it causes lingering pain. It hasn't been used a lot in recent years, so I don't know what the Supreme Court would say. Death penalty for child rapists is disproportionate. We have said that any crime that doesn't involve killing another person should not be eligible for the death penalty. So even rape of children does not rise to that. Okay, and then juvenile murders. Death penalty for juveniles who commit murder. We have now said that that is disproportionate because you're a juvenile when you commit the crime. You should not have the death penalty. And then the last one I want to talk about is what we call implied rights. So all of those rights were expressly listed in our Constitution. But the Supreme Court has said you have other rights too that are not expressly listed in the Constitution. And those are what we call implied rights. And one of the rights the Supreme Court says is implied by reading all the other constitutional provisions is the right to privacy. So the Constitution doesn't actually use the word privacy anywhere in it, but the Supreme Court says if you read other amendments, it implies that you have it. So free speech means privacy in your home, not quartering troops, search and seizure, individual rights protected in the Ninth Amendment, due process clause. If you look at all of those amendments together, the Supreme Court says you have a constitutional fundamental right to privacy. So if you get any questions talking about the right to privacy, it is a fundamental right. Okay, and it originally came from the case Griswold versus Connecticut, which was a birth control case. They were trying to make birth control illegal, and the Supreme Court said you have a right to privacy of whether or not you want to use birth control. Okay, so when you think about right to privacy, think about how it would affect issues like abortion. Is that a private health issue that you have a right to privacy for abortion? And then the other end of the spectrum, what about the right to die? Do you have the right to privacy in your decisions of whether you want to live any longer or not? So those all get sucked into this issue of the right to privacy, and if you have a fundamental right, and if it extends to that. So don't forget that I posted those practice problems online. If you're worried about the substantive due process analysis, make sure you go there and you try some of those problems, and then you can check them against the key and make sure you're on the right track. And then make sure that you do Chapter 2 assignment, your constitutional law analysis problem that's posted. So that's all that I have for Chapter 2. If you have any questions, please reach out. I know it can get confusing, but otherwise I will see you next week. We'll actually start talking about the law. Make sure you have your New York penal law. You have to have that so that we're going to use it in class every day now for the rest of the semester. And I'm going to show you how to use it next week in our lectures. So have a great day, and I will talk to you next week.